Okay, it's about a little bit after 8:30, about 8:33, 34 p.m. And it is Tuesday, December the 15th, 2020. Welcome to the final edition of Introduction to Criminal Law. I'm Professor Richard Wright, and I'll be here, for the next hour or less, providing details and information to help you to get prepared for the for this next week, and make sure that you're ready for the end of this week. So I'm going to go ahead and share my screen. Okay. So I hope you had a chance to look at this video. This is, as you see, the very last live lecture. The recording will be down here for those who are not here today. And then let's look at the calendar for the very last time. Okay. You can see that today is the 15th. You can see that reading assignment that I sent, the details, chapter 10, and the details that we're going to cover a little bit tonight. Initial post due tonight, murder or self-defense. Your reply post is due Friday, along with your written assignment, which is your time quiz. And then, of course, you know your live classroom lecture key phrase. And then, of course, there's a reminder right there on the calendar that the quarter ends at 11:59 p.m. on Friday the 18th. Okay, do not send any assignments to me that will be marked for the 19th. Even if they say 12 o'clock, they're not going to be graded, and you will not get points for it. You still have the opportunity to turn in weeks 4 through 6 if you have not, but it's going to be kind of hard because you only have a few days to get these assignments in that you missed. Can't do weeks 1 to 3, and you can't turn in the discussion posts for weeks 4 or weeks 5. Only week 6. Okay, so let's close this down. Let's go to the home page. You can see the announcement, the final announcement, telling you what the reading is, highlighting mental disorder, insanity, involuntary intoxication, mistake of fact and law, self-defense, key terms for practice, which I go over with you, and mistake of law, and then a practice quiz, which I tell you, make sure that you take each week. Remember, the quiz this week is going to cover weeks 4 through 6. 4 through 6. Recommend going back, looking at the quizzes, practice quizzes from weeks 4, along with these practice tools, 5 and 6 as well. And then I recommend finally that you look at the PowerPoints for the module itself. I don't know if you'll have enough time to listen to the lectures. Finally, the quiz which is timed. That's your sole written assignments for the week. And it will be due Friday. See, it's highlighted right here. Remind you too that the quarter officially ends Friday. Take time to complete end of quarter student evaluations. And of course, you know why my motto, Adversity Springboard Success, is there. If you had a chance to look at this video, and I hope that you'll each finish strong. A few people have reached out to me about turning in assignments. They saw zeros. I announced this early that every Monday I put zeros in for the assignments that were due that Sunday. That did not mean that that's your final grade unless you don't turn in the assignment. So let's go to the module titled Defenses to Criminal Liability. Again, your discussion post using this scenario, and then your initial post. The question is, will the clerk be able to justify self-defense? If so, explain, and if not, why? Identify a self-defense statute in your state or another state and explain why the elements of self-defense have or have not been met, and then reply to another student's post for your reply post. So your quiz, you know how many questions because you had it before, 30 minutes. And then remember, abide by the academic integrity misconduct policy when taking this quiz. Then, of course, your live classroom lecture. Those are the assignments, okay? Not very many, so you got your discussion post and your quiz and then your key phrase. So now let's go back. Let's talk about defenses. Okay, so we're going to talk about mental disorder, involuntary manslaughter, mistake, and we're going to close on self-defense. So mental disorder is an affirmative defense, and it means that a defendant, in order to utilize it, have to present it as the reason to say that they should not be charged with a certain offense or crime. And they're also known as justification defenses or excuse defenses. In other words, you're given a reason why you did this. So right now we're going to talk about mental disorder. So what happens is when a person is charged with a crime, they will argue that the reason they did the crime, and in defense is that they have a mental problem. And so what that mental problem does, it eliminates the satisfaction of what we call the scienter in the legal business, or the mental capacity to commit an offense. And so, like for example, a minor, a baby, might commit an offense and they don't have the capacity to understand what they're doing. So the consequences of what they're doing, and so they're not held liable. So I should point out to you that one of the most difficult defenses to raise in a criminal case, and I can tell you that in the years from 1978 to 2000, when I retired, I was never able to successfully produce an insanity defense, even in a few cases that were very, very, very bizarre, because the way that the insanity defense operates, and we'll talk about that in just a few minutes. So it's one of the most recognized affirmative defenses, and it means that a person is found not guilty by reason of insanity. that means that the person will then, if they're successful, not be sentenced on the crime, but instead they are placed in a mental facility and treated there. And normally they'll stay there until they rehabilitate, and then um, the person could be released back into society if the doctor, and by the way, the individual could not be tried again for the crime. And so it happens periodically. Some people may know the case of John Hinckley. John Hinckley was an individual who tried to kill President Ronald Reagan, and he shot at Ronald Reagan, and he ended up hitting um, his press secretary, Brady, and the Secret Service man by the name of his last name is McCartney. I always want to call him Terrence, but that's not really his first name. But McCartney was a Secret Service agent, and just recently, up until about a few months ago, he was the chief of police in our local area of Orland Park, Illinois, in Cook County. But he just recently retired. But we hear very rarely of individuals being released back into the community. So that is what happens. Now, this defense is allowed in almost every state except Kansas, Montana, and Utah. And there are various standards that are utilized to determine whether or not a person is mentally ill. And so the states determine under the standard that they operate to determine what happens to that individual after they're found not guilty by reason of a mental disease or insanity. And here are the rules, and we're going to talk about three of them. One is pretty easy because it only applies in one state, but I'll talk about that second. First, let's talk about the one that I remember learning first in law school. Called, it says M. Norton, but it's called Norton Rule. It's pronounced Norton Rule. And this was the one that goes back to the old British system. As you may or may not know, most of our laws in the United States of America originated from the law in England, except one state, and that state is Louisiana, which goes under the Napoleonic Code or the French. Ironically, I was just talking to an attorney a couple of days ago. We had an extensive talk about the difference between the two. And it is a total difference. And you can realize that the sentencing under the Napoleonic Code is much more severe than developed in England. So under this particular rule, the Norton Rule, a person is considered to be insanity at the time they commit an offense because of the fact that the diseased mind, the diseased mind prevents the person from recognizing that they were doing something wrong. So we refer to this particular method of determining mental illness as the right-wrong test. And so it says here that, give an example here, that at the time of a murder, the defendant thought that they were stabbing someone, when they were stabbing someone with a knife, that the knife was a straw. The knife was a straw. Or at the time of the murder, the defendant knew they were stabbing someone with a knife, but by reason of the mental condition, they thought there was nothing wrong with what they were doing, one or the other. So there are two variations. The person is out of touch with the actual weapon that they're using, as thinking that they really don't have that kind of weapon in their hand, but they don't, or that they were stabbing uh, with a weapon that they knew, but that they thought it was nothing wrong with what they were doing. And so, notice the example from Florida. The defendant had a mental disease or defect, and because of the condition, the defendant didn't know what they were doing, or it couldn't appreciate the consequences, or if they did knew what they were doing, just as I said a few minutes ago, the defendant didn't know that it was wrong to do that. Now, that might sound pretty weird to us, but that is it in a nutshell. I mean, that is reality there. So there are people who are like that. All right. So then we have the Durham rule. The Durham rule. And the Durham rule is only applicable in um, the state of New Hampshire. And so you find yourself, if you're in New Hampshire, then um, you could, hold on a second. Okay. So, okay. All right. Give me a second here. So the point of the matter is with the Durham rule, is that at the time, now it's going to sound almost like Norton, but it's a big difference. According to the Durham rule, the acts are the product of a mental disease or a defect that excuse criminal liability. This was determined in 1954 in the case of Durham versus U.S., where they said that the right-wrong test or Norton rule was too simple, and that mental illness was more uh, complex, and that some actions could be the product of straight mental illness. So the Durham test is even more liberal than Norton and stretches the purely intellectual question of this: did the defendant know the difference between right and wrong? That's it. That is the only question. They don't operate under the two tiers, whether did the person know that they were doing wrong or its consequences. Only the second part is applicable. So it's kind of like, we call it the half of the Norton rule. Again, that is applicable only in New Jersey. And you need to listen to these differences, because they're going to be something that you're going to be uh, tested on. And then the final is what we call the substantial capacity test. Now, um, I want to check something here. Right. Okay. So with the substantial capacity test, and that is the rule that we utilize now in Illinois, um, because of the fact that with the difference now of the substantial capacity test, Kansas, Montana, Idaho, and Utah that don't allow the insanity defense. In other states, the standards for proving this defense is widely used. And so in various states, you will discover that, let's say, for example, you could check your state. Okay. So the Norton rule is used in Illinois. I recall us using the Norton rule, but it's a modified version. But anyway, we use the Norton rule. But many states, the substantial capacity test um, has to do with the issue of whether or not an individual find themselves in a position where there is what we call substantial capacity to not know the difference between right and wrong, but rather is the result of a mental disease where it lacked substantial capacity. So it's, once again, the right and wrong is not applied here as it is in the Durham rule, and as it uses as part of the way in the Norton rule. But then it is whether the diseased mind lacked what they call substantial capacity to appreciate the wrongfulness of their actions. And Wisconsin gives an example of that in their statute. A person is not responsible for criminal conduct if at the time of such conduct as a result of a mental disease or defect, the person lacked substantial capacity either to appreciate the wrongfulness of their conduct. And so you should recognize that a person is presumed to be sane. All are presumed to be sane, which begs the question that there are some things that people do, particularly in criminal cases, where we would presume that they're not sane by doing that. I had a client in one of my very last cases. He not only he raped a person who came to the house. He lost control. He said raped the woman, tied her up, stabbed her, and put her in a garbage can, and um, he was found guilty of murder because I tried to adopt a plea for him because I knew it was going to happen, but he ended up going down and received natural life. And this was before the death penalty was done away with, because when he committed the offense, he was 17 years old. So anyway, um, the defendant brings forth the burden, as I said earlier in this session, that they were to determine if they were sane or insane at the time, but they have to bring out that they were not sane. And depending upon which state, the burden of proof to be successful is preponderance of the evidence or clear or and convincing evidence. It is not beyond a reasonable doubt. So the standard for criminal cases is, as you know, proof beyond a reasonable doubt, but that the preponderance that is necessary for the defense is preponderance of the evidence, or clear and convincing evidence. So when a person wants to argue the defense of a mental capacity, a separate hearing is held. We attorneys filed a motion requesting that. We request an examination of the individual. Usually the state has a psychiatrist. We had a Dr. Reifman in Cook County for many years, and he was known as a psychiatrist who never found anybody insane. Well, he did find a few, and I'm going to talk about one in just a few minutes from now. But anyway, so at the hearing, each side can, if you can afford a psychologist or a psychiatrist, they're very, very, very expensive. And so they're in that hearing, there are reports prepared, and each side presents their position as to why a person is considered to be insane or not insane, or competent or not competent. And again, the judge will determine it, or in some cases, a jury will render a decision based on whether or not the defendant is insane or incompetent in a separate hearing. Of course, if the person is insane, then they are tried. Okay, they're ordered to a mental health facility, as I said earlier, until they're deemed no longer mentally ill or dangerous. And a lot of people spend the rest of their lives in those situations. So that's what I'm going to say, all I'm going to say about the mental order or mental capacity defense. The next defense is what we call involuntary intoxication. Notice the word involuntary. Do not try to use voluntary. There is no defense for voluntary intoxication. Okay? So, in other words, a person cannot drink and become intoxicated and then claim intoxication as a defense. You cannot do that because of the fact that that's voluntary. Now, it also is an affirmative defense that is raised by a defendant. Now, let's take, for example, the evidence. Let's use Michigan. There's two of them, but let's use Michigan. A person under the influence or impaired by alcohol or drugs as a defense is prohibited exception. Definition states it is an affirmative defense to the specific intent crime of driving under the influence, for which the defendant has the burden by preponderance of the evidence, which is the lower standard of the two, that between preponderance of the evidence and beyond a reasonable doubt, that they voluntarily consumed or legally obtained and properly used medication or other substance and did not know and had no knowledge and reasonably should not have, that they would become intoxicated or impaired. Now, that can apply to people taking all kinds of medication. I know that I take amlodipine, which is a medication used for your blood pressure, and on it warns me about driving. However, some of those warnings that are on there are warnings because of the possible litigation that the manufacturer of the drug might face. However, there are a few people that might happen to, and usually it doesn't happen in those kinds of situations. So you have to be in a situation where maybe you accidentally took 2 doses of your medication. Some people take their medicine and forget they took it, and then will take it again, and they won't be at the stage where they are unconscious or anything, but that they'll be in a state where they could operate a vehicle or do something under the influence. And It says here that the intoxication defense can be applied in cases where criminal law was violated and the elements that are necessary for the state of mind, in other words, the person didn't know the ability between right and wrong or couldn't appreciate it because they were so high, and that it was involuntarily done, and it negates their ability to meet the standards for having committed the crime itself. Okay. Now, an example here given in this last paragraph before we conclude this involuntary intoxication issue, if a person has their drink spiked, you're slipped a Mickey, as I've known in some instances, um, or you have an unforeseeable adverse reaction to some medication. And here's an example. For example, a college student, Jim, he was staying up all night to take a test and study the next day, and he doesn't want to fall asleep in class as he's going to be taking the test. Well, a classmate offers him a white pill, but he tells Jim that it's a caffeine pill and that it'll keep him alert. However, the classmate did not tell the truth, and the pill was actually a methamphetamine hydrochloride pill, and it messed with Jim, causing him to go to a panic and a rage. He was out of control. And so while he was involuntarily intoxicated, uh, he breaks windows, destroys merchandise. The police arrive, arrest him. Jim, if he's able to prove that he was involuntarily intoxicated, could be found not guilty of vandalism or disorderly conduct or any other offense, which begs the question law enforcement people need to understand dealing with mental health and also dealing with individuals who find themselves in an intoxicated or inebriated state. So you can use that as a defense. But remember two parts. One, it must be involuntary, and so much that it destroys the ability for you to know right from wrong, and it'll be determined by preponderance of the evidence. Again, there is a separate hearing to determine that, and it's triggered by a motion that is filed in court that we often as attorneys would do. We're going to talk about two other defenses: mistake of fact and mistake of law. We're not going to spend a lot of time on them, but I will talk about the mistake of fact first. And mistake of fact can occur when someone is, now listen to me, not ignorant of the law, because ignorance of the law is no excuse. I'm sure you've heard that before, and it is true. But here's a definition that is given under one of the state statutes that Missouri uses. It says a person is not relieved of criminal liability because he or she engages in such conduct under a mistaken belief of fact or law, unless the mistake negates the existence of the mental state of that individual. And so states like Missouri and other states say that the mistaken action must be related to an element of the law that's in question. For example, Lisa is making a large purchase of goods, including a push mower and the large box she puts at the bottom of the cart. And the top of the cart is filled with other items, and she pays for them. Then she's distracted either by her cell phone or something and doesn't pay attention to what the clerk is doing to ensure that all these items are scanned. And so she ends up rolling the cart out after she made her payment, and the police or loss prevention officer calls the police and says that Lisa should be charged with theft. Well, Lisa would probably raise the defense of mistake of fact. In other words, claimed that she had every intention of paying for the merchandise, um, and that she didn't intend to steal, but the clerk uh, neglected to scan the lawnmower. I remember a case where I was in a Walmart, and most of the time I'm in a Walmart. I ride one of those little electric carts because the concrete is bad for my back. And so anyway, I remember we had some items in there, and all the items were taken out, and I had forgotten my wallet. So my wife, after they had rung it up, my wife waited, and then I rode the cart out to the car. Well, when I got out to the car, I discovered that there was a bottle of a soda that hadn't been apparently scanned, and it was in my buggy. Well, I didn't intend on stealing that. In fact, I took it back in and told them, I said, you forgot to ring this up. And they said, oh, don't worry about it. They gave it to me. But the point of the matter is that if I had been stopped by the loss prevention officer and charged with theft of that one little bottle of soda, I would have claimed the same defense as an error. And you know those kinds of things happen. Okay, so that's a mistake of fact. All right. By the way, you will be tested on that. We will have some practice tests on that too tonight. Mistake of law. Now, this is a little more tricky. Um, this is a violation where a person believes that the actions they did were legal. And as I said, it is not the same as ignorance of the law. And mistake of the law can be applied in cases where there is a determination that the law is unconstitutional or determined to be unconstitutional, that the person acted in good faith consistent with a court opinion, but misapplied it. In other words, trying to represent themselves. A person acted on advice that was given by a person responsible for administering the law, such as a law enforcement officer, or a person committed an act contrary to law that had not been published. It had been passed but not published, which means it wasn't released to the public. And so these are elements that are found in some jurisdictions like North Dakota. If there's a reasonable reliance upon a statement contained in a statute, a judicial decision, an administrative order, or an official interpretation of a public servant that allows that individual to do something. But you should know that there's a difference. Um, and an example in a mistake of law defense, and there is no reference to ignorance, but rather to it's more like reliance rather than ignorance. Now here's an example that we'll use, which is an excellent example that they put into this lecture. Paul had a suspended license, and he drove his ATV to work. His mother reached out to the sheriff's department and asked if it was okay for him to operate the ATV even though his license was suspended. And he was advised that he could operate his ATV as long as he followed other laws. So one day, Paul was on his way to work, stopped, and cited for operating with a suspended license. Paul was convicted of operating while driving on a suspended license, and the trial court didn't permit the jury to consider mistake of law because he relied upon what the police officer told him. Well, Paul appealed, and the conviction was overturned based on the theory of mistake of law, because the Court of Appeals judges said that the trial court erred and should have allowed the defense, because Paul only drove because he relied upon the bad advice that was given by the deputy sheriff who was charged with enforcing the law. So the question is, does that same thing apply if you're represented by a public defender and you do something? That could possibly be too as well. So the fact of the matter is um, if someone is held responsible for enforcing the law, probably the best example is dealing with a law enforcement individual, such as the sheriff or police, giving the advice as given. Okay. Self-defense, one of the most commonly used, excuse me, in criminal cases where there's some violence involved. And I have, as an attorney, been very successful utilizing self-defense in cases. In fact, my very first case was a double murder case where I was successful in using self-defense because of the fact that I proved that my client um, shot the individuals, killed the two individuals while protecting his life and the life of others. The argument, though, was made that because my client shot these two guys in the back, that it wasn't self-defense. Well, the fact of the matter is I was able to prove that the shots that killed the individuals were consistent with those individuals who did have weapons, were facing him with their weapons drawn, and he got his shots off first, and they hit the ground, and they were dead, and then he stood over them and shot them. So a medical examiner's report that I utilized in that case gave me the benefit of a victory there. So um, remember that in self-defense, it must be consistent with the force that you have to meet. And so the defendant has to prove that there was a reason for their action. So the interference can include being punched, shoved, kicked, grabbed, strangled, or held against one's will, but the force has to be necessary to stop it. Now let's consider the scenario here of Bob walking on the sidewalk with his girlfriend Margaret, and they're approached by this drunk guy who he threatens to punch Bob in his face. Bob attempts to avoid the conflict and says to the guy, keep walking, but then the man shoves Bob, draws his fist back to hit him. Bob is in apprehension of being hit. Bob reacts quicker, punches the man in the face, and the man falls onto the ground. Now, probably at this point, it's okay. But then Bob, who is upset, because the man tried to insult him, he jumps on top of the man, beat him until he became unconscious. And Margaret had to pull Bob off till the police arrived. And so it is quite clear that the initial force that Bob inflicted upon the individual was justified. But when he went beyond that, then he went beyond self-defense and could be found guilty of a homicide if the person died. So look at what under my great state, it says justifiable use of force can answer these questions. Illinois says that a person is justified in the use of force against another when and to the extent that there is a reasonable belief that the conduct is necessary to defend themselves against another, or such as the use of imminent unlawful force. However, one is justified in the use of force intended to likely cause death only if you reasonably believe that the force is necessary to prevent imminent death or great bodily harm to himself or another, or the commission of a forcible felony. That fit the mode of my first case that I was talking about, where the person got his gun out. So So Bob's initial use of force was justified, but when Bob committed great bodily harm and beat the man unconscious, it's important to note that self-defense, to be successfully claimed, it must demonstrate that the force was imminent, that it was going to happen. But Bob couldn't do that. And so, in most states in the U.S. don't require a person to retreat or to move before using this. Um, this is a concept known as stand your ground. This was made famous in the Trayvon Martin case. Um, and to me, that case didn't make much sense. But stand your ground doesn't require a person to retreat. So it means that that person would have been engaged in, um, they were engaged in lawful activity and have the right to be wherever the attack occurs. And before using force to stop in unusual circumstances. Therefore, you can't assert stand your ground if you're committing a crime when you are attacked. So if you're committing a crime and you're attacked, you can't do it. Also, people cannot claim self-defense in cases where they provoke the attack as well. In some states will not permit a self-defense claim in instances where the person attacked could have avoided, such as a duty to retreat, which I always thought was the most ridiculous thing um, in the world. And so take a look at your state to determine whether or not you live in a stand your ground state or a duty to retreat state. At one time, we did have duty to retreat, but I think that was done away with because we all hated it. It didn't make sense because of the fact that you could be injured or someone else could be injured in the meantime. Got to kick it up here. Battered women syndrome. This is a defense that's raised by individuals who are the subject of violence, primarily domestic violence, where what we call BWS, and to justify the killing of an abuser because they've been the victim of domestic abuse or a cycle of violence constantly. Now, in order to do so, it must be contemporaneous, though, with the danger. So it's been, for example, let's use this one here. Diane, who's been physically abused and battered multiple times by her husband, Jim, over 10 years. And each time Jim's drunk, and that's when she's battered. And the worst case has even been knocked down and choked unconscious. One night, Jim comes home drunk and they begin to argue over Jim's drinking problem. Jim begins to escalate, and Diane, lawfully and fearfully that she's going to be battered again, shoots Jim. And she's likely to argue the battered women syndrome. So it's a case that can be used. I know of a friend of mine that she had a violent husband, and she waited for him to go to sleep and then shot him. That was the problem with the case. But I believe that with the jury, that you can still argue under the circumstances. Now, of course, so in that jury, we would want some women on that jury, not just men. Even though some men can appreciate and understand it, but you'd want for sure some women. Probably women who were the victims of that would probably be excused from the jury, either by the judge for cause or either one of the peremptory challenges used to get that person off the jury. But anyway, that's the battered women's syndrome. The castle doctrine means what it says. Your castle is your home, your place where you're supposed to be most vulnerable. And you don't have to retreat. And a person entering, you can use deadly force if a person is done so to protect the area where you live. And the castle doctrine operates in various states. Okay, so just be aware of that. Um, let's use Kentucky castle doctrine that says when it doesn't apply, the person against was forced to use was a lawful resident or had the right to be inside a protected area. So if it happens and you had a right to be there, then that's a different. You can't use it. But if an intruder is involved there, and you could read some of these other things too. The final thing revolving this is police officers have the ability to use force, but their force is based upon all the surrounding circumstances and should be utilized in a fashion commensurate with the situation. For example, generally it's held that if a person is running away or fleeing and they don't appear to be a danger to the community, then the police cannot use excessive force, such as shooting those individuals. Now, again, unless they have a weapon themselves that they can possibly use against someone. And so remember, though, as we already know, that the force by a police officer is under extensive review, and that there's a lot of excessive force cases now that take place involving law enforcement and the use of force. The point of the matter is deadly force is really scrutinized seriously, and it should be only when another person or you are in danger. I don't agree with this statement. Thankfully, the use of deadly force and police officers is rare. That's not true. That's not true. It's happening too much. But part of the reason it happens is because of the poor training, such as doing away with things like the chokehold, people like George Floyd and Eric Garner and individuals like that. Uh, Police not being able to understand how to deal with situations when a person is mentally ill. So anyway, set deadly force is something that is a serious problem in law enforcement right now that you have to be trained. From a Second Amendment perspective, sometimes the mere presence of a firearm can prevent the use of deadly force. That's the argument that people say they want guns and those kinds of things. So we'll skip over the rest of this. And that's it for what we have in class. So now let's look at some of the practice things. Now it's about 9:28, so let's take a few of these. Key terms. Again, I highly recommend utilizing this, showing you how it works, getting it going. Where you're given a scenario, defendants may admit that they committed a crime, but the law proves an exception for which they should not be guilty despite their admission. And so here's the question, here's the answer. We'll call affirmative defenses. That's all we've been talking about is affirmative defenses, okay? The type of affirmative defense, which includes mental disorders, involuntary intoxication, mistake of fact, and mistake of law, which excuses the unlawful acting. You call those excuse defenses. That was the excuse that's utilized. A test applied to determine if a person was sane at the time he or she committed a crime to be successful. The defendant must demonstrate, because it's affirmative defense, that their mental illness prevented them from knowing the difference between right and wrong when the crime was committed. You should recognize and know what test that is. Do you know what test that is? You can type it in the chat box. What do we call that test? It's called the Norton rule. The Norton rule. And then you can go to the next one as well. So utilize that as a basis for helping you prepare for the test. And like I said, you should go back and do the weeks before that from 4, 5, and 6. Uh, Practice a mistake, a law, or fact. So you're given a scenario. Jane has a white cat named Snowball that wears a pink collar and is let outside each day. And one day the cat doesn't return. A few days later, while out looking for her cat, she finds Snowball and brings her home. However, she realizes that the pink collar has a tag with the name Princess on it. Jane contacts the police. However, she fears that she will be arrested for theft. So, what is this? What's her defense? So, it's either one or the other. Which one is it? Yep, mistake of fact. Because she realized that wasn't her cat because it was an error. That's like picking up the wrong bag or stuff like that. Eric waves down a police officer and asks, my landlord locked me out of my apartment. Can I break in to get my stuff? The officer says, yeah, it's your place. Eric breaks in, and the landlord demands he be arrested for burglary. What's his defense likely to be? Yeah, because he relied upon the police officer. That's correct. Okay. So those are 7 altogether. You can look at those, and that gives you the ability to prepare for that. I do recommend doing it. Say it all the time, but I can tell when the grades come back that people don't believe me. And then the final important is the practice quiz, which actually, as I already said before, it contains questions that you may see in one form or another. So you're defending a case where the defendant, Derek, is accused of killing his friend during a schizophrenic episode, and he believed he had to kill his friend because he was the devil. You don't believe that Derek knew the difference between right and wrong at that moment. The what rule would be most applicable in this case? You think the Durham? Let's see. I don't think that's right. Nope. Which one? The Norton rule, because it was not knowing right from wrong. Um, yeah, but that needs to be your first choice, because if it's your second choice, you missed it on the test. David is hanging out with friends at a local bar. Somebody places an unknown liquid in his drink. So basically, he's a Mickey. He goes off, strips off his clothes. He's arrested, transported to a local hospital. The next day, David has no recollection. What affirmative defense will he claim? Which of these 4? Yeah, okay. But remember, notice that it wasn't voluntary. Okay, so you're right. Uh, It was involuntary. Remember, it's got to be involuntary. One last one. What level of proof must be met in order to successfully prove an intoxication defense? And if you say probable cause, you fail the class. You said beyond a reasonable doubt. Is that what you say? Okay. Actually, this and this are two standards that are utilized for search warrants. Okay. This is the toughest standard, but this is the standard that's appropriate for an intoxication defense. That's the answer. Okay, so you need to watch it. You got to be careful, and you got to make sure you use the right terms. I covered all of that very, very much to the point. All right. So, any questions? Any questions? Okay. Yeah, just be careful. Watch the tricks in there. Be very careful. The other thing is reminding you of your assignments that I mentioned earlier. You have the discussion post, the initial post due tonight, reply post due what day? What day is the reply post due this week? You can do it then. It's due Friday, the last day of class. That's okay. Thursday would be okay. Long as you didn't say Saturday. Okay. Because it's been Saturday before. Because the course ends, as I said earlier, for those of you latecomers, it is Friday the 18th. The course absolutely ends. And I said before, those of you who have problems, you can turn in assignments from weeks 4, 5, and then of course 6. But you cannot turn in weeks 1, 2, or 3 unless I had made arrangements with you before that. You cannot turn in a discussion post for weeks 4 or 5. Those are past. Only week 6. So get your assignments in because all grades are due for me to um, have posted before the end of the 22nd, which is a week from today. So all final grades will be in, and I'll probably have them in before that. But your opportunity to get materials and information to me is ending as of 11:59 p.m. Friday. Okay, well, I'm going to give you a key phrase, and the key phrase is affirmative defenses. That's it. Affirmative defenses. You got to spell it right. It's what we talked about the whole time this week. And so I just want to say to each of you, it's been a pleasure teaching this class. I will be teaching it again next term, term 2. And thank you. Happy holiday to you. And I want to say before you guys do go on holiday, get your assignments done appropriately so you can enjoy those 2 weeks off. Um, and so I will be teaching um, in the winter, again, term 2, drugs and crime and criminal law again. So if you didn't pass this course, so I might see you again in term 2. I hope not. And then I will be teaching in term 1 realities in I think it's Realities in Criminal Justice. I think that's the name of it, and Contemporary Issues in Criminal Justice, as well as Introduction to Corrections. So um, the, that's those courses I mentioned first are usually what we call exit courses. And actually, what's most interesting about those two, I haven't seen them yet, but that this will be the first time that these courses, I believe, are taught in the 5.5 mode. Prior to that, they were 11 weeks. And in both of those classes, there was no textbook involved in them. I know there was not one in Contemporary Issues of Criminal Justice, but I'm looking forward to seeing uh, how that pans out. So I'm going to say again to each of you that if you need me, you know how to reach me. I've had students many times after class is over when they get ready to try to do things. And then at this juncture, usually I see many of you in my other classes that I teach, like constitutional law, or I might see you in those other two classes I mentioned. Um, those are the main ones they have me teaching now. Sometimes I teach evidence. I haven't taught that in a while, but I love teaching that course. That is when you're a former lawyer, you certainly appreciate teaching that course because the rules of evidence are so important in terms of what can and cannot be admissible in a court of law. So I'm going to say good night to you. Again, happy holidays to you. Merry Christmas, Happy Hanukkah, Kwanzaa, whatever other holiday that you celebrate. Enjoy it. Remember one thing, it's different this time. Uh, as I said to you guys during Thanksgiving, we're not having people over. We're not having people over this time. We're going to celebrate at home. I see we got um, um, the, the what is it? The shots now. We've gotten that, the vaccine. So now it's being rolled out. I will probably be one of the candidates that will come in the second wave because of my race and age, because I'm 70-year-old African American male, so I'm in the high risk group. There are people who are afraid of taking the the shot because they don't like it. I don't take the flu shot. I haven't taken the flu shot in a long time. Last time I took it in the 80s, but I'm taking this one. My wife is afraid to take it. There are people say there are side effects, but I still recommend getting out and taking it. And then also recognizing that even after taking the shot, it's going to take some time. We're still going to be wearing masks to protect ourselves, and so well, again, I hope I see some of you down the road, not repeating the course, but in other courses. Again, have a good evening, and again, stay safe. So good night.